I want to get back to our top story right now. Those demonstrations at the Florida Capitol in Tallahassee demanding the repeal of Stand Your Ground, the controversial self-defense law, which allows the use of force, deadly force even, if necessary. George Zimmerman's legal team did not invoke the law as part of its defense, but it did impact the judge's instructions to the jury. And the juror, B37, told our Anderson Cooper exclusively that the Stand Your Ground law played an integral part in the decision to find him not guilty.
Because of the heat of the moment and the stand your ground. Then he had a right to defend himself. If he felt threatened that his life was going to be taken away from him or he was going to have bodily harm, he had a right.
So even though it was he who had gotten out of the car, followed Trayvon Martin, that didn't matter in the deliberations. What mattered was that those final seconds, minutes, when there was an altercation, and whether or not, in your mind, what the most important thing was whether or not George Zimmerman felt his life was in danger.
Well, that's how we read the law. That's how we got to the point of everybody being not guilty.
That's the law in Florida right now. Let's discuss what we just heard and more. Joining us, the Reverend Jesse Jackson. He's the founder and president of the Rainbow Push Coalition. Also joining us, David Webb. He's the co-founder of the New York City group Tea Party 365. He's the host of the David Webb Show on Sirius XM Radio. Gentlemen, thanks very much for joining us to discuss this important subject. Reverend Jackson, why do you believe the Stand Your Ground law in Florida should be repealed?
It is provocative and lends itself to subjective interpretation. Since it has been law, deaths have tripled in their numbers, lends itself to stereotype. And of course, in the case of Zimmerman, he was an armed man who saw a boy who he thought should not be in that neighborhood, but who actually lived there. He pursued him over the objections of the dispatcher. He stereotyped him. Ultimately, that was a confrontation. He murdered him, and he walked away. Had he not been armed with that gun and pursued him, it never would have happened. And furthermore, the jury took into account that he had the right to be there and the right to kill him. I disagree with that strongly.
That's the law, though, in Florida. Go ahead, David. You want to respond to that?
Well, first, Wolf, I do believe we should have a review of the Stand Your Ground law. I'm concerned in Florida, where in Miami, for instance, gangs are using it as part of a defense if two gangs have an altercation and there's a shooting, and I've been talking with judges and attorneys down there about that. So I do believe in reviewing the law and making sure that if it needs to be rewritten, that's done so it's effective. What the Reverend is talking about, however, is he invokes the events leading up to the altercation. The law, as it's written, allowed for that. The defense, as you pointed out, did not use it as part of their defense, and he was acquitted of all charges as a justifiable shooting. So we should stay within the boundaries of the law as it's written, and we should have a review of the law, which the governor's office did begin, and we should continue with that.
Go ahead, Reverend Jackson. You got a problem with that?
Yeah, it was obvious all the while that that was a law that's provocative, and people have more access to guns with these tendencies to stereotype. It lends itself to an increase in killings, as in Florida they have tripled. What concerns me very much now is that you have one interpretation in Sanford where a man who killed a man walks away and now has put his gun back in his holster because he's set free. And Marissa Alexander here in Jacksonville is facing 20 years.
We're going to get to that case.
Already having served 3.
Reverend Jackson, we're going to get to that case shortly, but let me just point out this. And the Tampa Bay Times did a study of the Stand Your Ground laws in Florida, 200 cases over the past few years. The study came out last year, and among other things, they concluded this. And David, pay attention. Defendants claiming Stand Your Ground are more likely to prevail if the victim is black. 73% of those who killed a black person faced no penalty, compared to 59% of those who killed a white person, if you will. So there seems to be a problem if you believe the study conducted by the Tampa Bay Times, which is a serious newspaper.
Well, and I would have to look at the full metrics of that before I take it just on face value. There are other factors in this, Wolf, and it's not always just a law. And by the way, the Reverend mistakenly characterizes gun ownership as a result, or growth in gun ownership as a result of Stand Your Ground. They cannot be inexorably tied together as a factor. When it comes to stand your ground, however, if the real issue here that the Reverend and the NAACP wants to put on the table is stand your ground, then I hope they review the case of Trevor Dooley, a 69-year-old black man who shot a white man and asserted stand your ground as his defense. But what we have is that when a white shoots a black, there is a public outcry, and then we get into the race issues. But when a black man shoots a white man, there's not the same outcry over the very same law that's being asserted.
Go ahead and respond, Reverend Jackson.
You see, the law itself lends itself to this, the fact that more blacks are shot. It doesn't really matter. There is simply more killing. These stand your ground laws make us less secure. They do not make us more secure. And you have the travesty in Sanford, Florida today, because Mr. Zimmerman felt he had the right to exercise that law. And the jury culturally identified with Mr. Zimmerman. And since the jury did not have a black or a man on it, there was no counterbalance in the internal debate about it. They used this law.
You know, this is so disingenuous of you, Reverend Jackson. One, to tie facts or to tie assertions as facts, and then to go into if there wasn't a black or there wasn't some. The jury was a jury chosen by both the prosecution and the defense, people that were excluded and people that were kept as juries. And it is such a ridiculous assertion by you to say that those women could not have come to a decision just because of the color of their skin. That is part of the problem with what's happened in the travesty that followed the tragedy. Trayvon Martin didn't deserve to die. And this was a tragedy where two elements that I wished had never met, and we don't know what happened in those 2 minutes, those key minutes. But to take that ridiculous assertion is, one, an insult to the system in the United States, and it's also an insult to those women and the people who fought this case on both sides within our justice system.
In the United States, jury of your peers matter. There was no peer among the prosecutors nor among the jurors. And so
it doesn't say the jury should be of their same color.
It's not so much their color as it is their culture. They felt that not only was he had the right to pursue Trayvon, but he was doing a good thing by pursuing him. And then went on to say, Mr. Zimmerman, that these punks get away with this stuff too much, and they rob people. That's a stereotype. Here was a boy going home. He thought he was a boy going home. He thought it was in the wrong neighborhood. He, in fact, himself was in the wrong neighborhood, and he did the wrong thing.
But so your assertion is if the jury had come down your way, they would be well. But because they didn't come down the way you would like it, now you want to blame the jury. Is that essentially what you're saying?
What I know is that when an armed man kills an unarmed boy,
but the question is about the jury,
and then walks away for 44 days, but the police department that says not even a blood test, or a drug test, or an alcohol test, has all those freedoms and comes out the winner in the end, where the victim becomes the source of provocation. That does not seem to be logical.
Gentlemen, hold your thoughts for a moment. We're going to continue this conversation, but the point, and I'll let you, we're going to come back to this, but the prosecution and the defense attorneys, they both accepted these 6 women as the jury. They went through a lot of folks who could have been on the jury, but both sides accepted these 6 women as the jury in Florida. All right, stand by, David Webb, Jesse Jackson. We're going to continue this conversation when we come back. Also, another Florida case in the spotlight right now because of the stand your ground law in that state. A woman claims self-defense, ends up, though, serving 20 years behind bars. Stay with us.